a call, a people, a gathering of leaders in faith and in Christ, in commerce and industry, in sports and entertainment, in beauty and fashion, in government and in education, in spirit and in truth. We are moved with a passion and zeal for the lost and the hurting world. We are equipped to build bridges and raise platforms to society. We stress cultural relevancy and yet harmonize our diversity as we communicate by all means our message. We are a gathering of the saints, raising leaders and rebuilding nations.
So Attorney L. Ray is a highly experienced business immigration attorney and the founder of Ray Law International PC, a boutique immigration law firm with offices in Chicago, Michigan, and New Jersey. With over 20 years of legal experience, Mr. Ray has established himself as a leading expert in the field of business immigration law, providing personalized and strategic counsel to clients around the world. Mr. Ray has extensive experience working with a wide range of clients, from small startup to large multinational corporation, and is known for his ability to provide creative and effective solutions to even the most complex immigration matter. He has a deep understanding of the legal and regulatory landscape surrounding business immigration and is committed to staying up to date with the latest development in the field. Over the course of his career, Mr. Ray has helped countless clients achieve their immigration goals, whether that involve securing work visa, green card, or other immigration benefits. He is widely recognized for his exceptional client service and is known for his ability to communicate complex legal concepts in a clear and concise manner. Mr. Ray earned his Juris Doctorate from Wayne State University School of Law and is a member of the American Immigration Law Association, the Michigan State Bar Association, and the Society of Human Resource Management. He is a frequent speaker on immigration law topic, and his regular contribution is in nation and international social media outlets on issues related to business immigration. With Jesus' joy this morning, please join me as I welcome Anthony Ray.
Thank you, Pastor. Good afternoon, everyone. It is my pleasure to be with you today to pray, worship, and learn today in the Lord's house and among fellow brothers and sisters in Christ. For many of you, this is the first time you have seen me, and for all of you, this is really the first time you have met me. So I think it's only appropriate that I take a little time to tell you a little bit about who I am and how I got to where I am today. First of all, I grew up in a Christian home. Both my parents are from Alabama, and like many of them and their siblings, they, in the 60s, moved up north for better employment and lifestyle opportunities. Many of my aunts and uncles moved to Chicago, and they are still here today in the Chicago area with their families. Some of my other aunts and uncles moved to, of course, Gary, Indiana, New York, and for whatever reason, because my father was in the Air Force, he was the only one that really moved to Detroit, Michigan. That's where I was born. I was born the third child after my two older siblings, and both my parents were really faithful and involved in their church. Every Sunday afternoon, we would, after church, visit shut-ins and elderly people, so that was sort of a part of what I grew up with, giving and serving other people. That's how we spent our Sundays. I became a Christian. I accepted Jesus Christ as my personal Savior when I was 11. And just personally, my father always told me to read Proverbs every year. So that's sort of been my staple, not just because I'm an attorney, but because I think it's very applicable and important to go through Proverbs and just apply that to my life. At a very young age, even though we were born in Detroit, at about 5, we moved out of Detroit and out of the Black community, just completely opposite. So we moved to the suburbs of Detroit. There, really minority, there was less than 1%. That's where I grew up, and that's sort of my background. Michigan, it's not as diverse as Chicago is. So during high school, I was able to take a goodwill tour over to Taiwan. That was my first time out of the country. It was there that I decided that I wanted to learn a foreign language for my undergraduate degree. I have always wanted to be an attorney. I really wanted to help people and make a difference in people's lives. So at the University of Michigan, I graduated, I majored in Japanese. I also took 2 years of Chinese as well. I enjoy foreign languages. I graduated undergrad in 3 years, and I spent 2 years in Japan. In Japan, I worked as a missionary and an English teacher, where I experienced in 1995 one of the largest earthquakes that I've ever experienced, which was one of Japan's largest earthquakes. And I also experienced a lot of growth personally, both spiritually and as a young man at that time. Right. After Japan, I came back to Detroit and went to Wayne State Law School for my law degree, and graduated in 1999. In 98, after I graduated from law school, I practiced both bankruptcy law and immigration. So from that point, I've always started to build my client base and, just building networking, growing the business and my network so that I could provide for my family. That's what I enjoy doing. For just a little bit more background, I got married in 1998. My wife and I have been married for 25 years. We have two young men, 22 and 17, and we're very proud of both of them. All right, so now today there's 3 paths that I want to talk about regarding how to settle into the U.S. Now, for some of you, you may have friends or maybe yourselves have gone through one of these 3 paths. They're not the only paths that are available. However, just for today's discussion, I wanted to present these 3, and then if there's others that you have, I've been more than happy to discuss those and talk about them. Now, immigration law, there's many options, there's a lot of variations, and there's a lot of facts that impact whether your case is going to be successful or not. But remember, the facts of each case and the participants will impact how smoothly or difficult the case will go. It really takes both, not just the knowledge of the attorney or the skill of the attorney. So the 3 areas that I want to go talk about for settling and coming to the United States, first is asylum and refugee pathways. The second is family sponsorship. And third, employer sponsorship. Now, even though I do a lot of employment-based immigration, I feel it's very important that we help other people in other areas. All too often, and maybe you've heard of that, where people are taken advantage of and the attorneys don't take responsibility, or whoever in the society or community doesn't take responsibility in helping to make that person whole. So the first case study is asylum and refugee pathways. So for those who are not familiar, the pathway is for individuals who have an immediate and present well-founded fear of persecution due to race, religion, nationality, political opinion, or inclusion in a particular social group. So often we hear it in the news where there's many people at the border, or there's, a million people in immigration court or going through asylum. This is what those individuals are going through. Others, they are refugees outside and they get permission and go through this path outside of the U.S. Those are refugees that come in. Either way, it's a similar test. People have a fear. They're fleeing from their homes. So our case study for today in this category, we had a client who's from Mexico. And there was about three or four brothers who lived there. And they were targeted by the gang. The gang members killed one of the brothers. The gangs also threatened and harassed the remaining living brothers that if they would testify against this gang member, that they would harm them and, hurt their family. So in this particular case, the brothers had firsthand testimony, which was key in asylum or refugee cases. We also had police reports and other evidence to make the case very successful. All too often, maybe you guys are familiar, refugee and asylee cases, they're often difficult for two reasons. One, because you have to get the evidence and the documentation, which is not always readily available. And sadly, the other part of this pathway to settling in the U.S. is the individual, unfortunately, has to experience some horrific, unfortunate event that none of us wished upon them. However, this is one pathway that many people apply for. So if you have any questions about asylum or refugee later, just let me know. While we do handle some, we don't do a lot of these. We usually give them to other attorneys. However, we do in-house handle several affirmative asylum cases. Those are people who are here lawfully who want to apply for asylum. So we do help them navigate a very difficult process. The second area that I wanted to go over is family sponsorship. This is probably one of the most popular or famous. The categories, as you may well be aware of, if you're not, I'll just go over them real quick. First, immediate relatives, spouses, parents, and children of U.S. citizens. That's the first and most common category. The other categories are set with a quota, meaning we put a limit on it and people have to wait for a period of time. This includes U.S. citizens, unmarried children under the age of 21. The next category are for green card holders, spouses, and children under the age of 21. The next is for green card holders, unmarried children over the age of 21. Additionally, there's two more, U.S. citizens, married children, and finally, brothers and sisters of U.S. citizens. Notice that aunts, uncles, nieces, cousins, parents of green card holders, or even married children of green card holders are not included in these categories. So while you may have other family here, cousins, aunts, uncles, they really can't help you out, unfortunately. Now, in our next case, I want to talk about a case that did not necessarily have a happy ending, okay? So Mary, who's a U.S. citizen, before she retained us or came to us, she went to Nigeria, married her husband, and filed the immigrant petition on her own. Of course, it got delayed because she didn't have all the documentation. Google doesn't analyze your specific case, okay? You can get some information about it, but each case is going to be different, and you'll see in this scenario. And then unfortunately, John, her spouse at this time in Nigeria, his immigrant visa at the consulate also got denied. Well, it came to find out when they retained us that Mary, who had relied on her husband to file the divorce here in the States, failed to file the paperwork. She was still married. And in addition, John, because some countries have allowed for multiple spouses, he had not yet gotten his divorce in his home country as well. So the strain of correcting the problem, getting both of the divorces and having the couple get remarried, put a strain on the relationship. And unfortunately, Mary gave up. So the point of this is proper analysis, planning, and execution are vital for all legal matters, and that includes immigration as well. Often we think immigration is just filling out forms, and yes, someone did it back in the 70s or 80s when the government didn't care. But things are very different, especially since the past administration. And finally, what I wanted to cover is our third category is employment-based sponsorship. This is where a U.S. employer will sponsor an employee, foreign national, to come and settle in the United States. If you are not aware, there are numerous categories for temporary work visas, such as H-1Bs for professionals, also for H-2Bs for, people who are skilled workers. Think of your golf courses or landscaping or even construction. However, with U.S. employers desperately looking for workers, they are increasingly turning to the green card sponsorship for workers they need to grow their business. So every week we receive phone calls from employers saying, I can't find anyone to work in my business, whether that's a Montessori or a multinational corporation. In this case study, we're going to turn our attention to employer sponsorship. And we're going to look at there's 5 employment-based categories for employers to choose from, but we're going to look at the third one. The third one focuses on professionals, skilled workers, and also all other workers. So it really doesn't matter the person you want to bring in. They could be, a sheep herder, they could be an engineer, they could be the president. There is a visa category to bring them in under one of these categories. So in this scenario, we had a client who has an adult home care, and he couldn't find anybody. So he approached us, but he's already identified a foreign national, in this case, the Philippines, that he wanted to bring over and to work in his business. So the process is, I'll give you a simple overview. It's not easy, but it is an overview. First, the U.S. employer has to test the U.S. job market. So if you're a U.S. citizen, don't worry. If you want the job, you get first bids on getting the job. The second thing is the U.S. employer will petition for the foreign national to bring them to the United States. And then finally, in this case where the foreign national is in their home country, in the Philippines, the foreign national will apply for their green card abroad or an immigrant visa. And when they come in the United States, they're authorized to work. So these are 3, fairly common areas that people can use to enter to the United States. Asylum or refugees. The second is family sponsorship. And then finally, if you have a U.S. employer, you would be able to use one of these tools. Are they easy? Are they convenient? Not really. However, these are the only sort of vehicles we have to bring people into the U.S. Now, as the pastor had mentioned, we wanted to set some time aside for you guys to ask your own questions, if you have them. The questionnaire sheets, those are there. Feel free to fill those out if you feel that you have something very private that you want a little bit more confidential. If you have general questions that, can help the group or help other people, or even a friend, feel free to ask, let me know. We're here to help, okay? And that's really when Pastor asked whether I would come and help or speak, I said yes. We've all have a lot going on, but it's a good chance to really help and make sure people get the right information or clarification. And even if I don't know, I'll research it and get it back to you. So with that, I guess, Pastor, shall we turn it over for our Q&A session? So I'm going to summarize the question. And feel free to write anonymous if you don't want to put your name on here, which is perfectly fine. I'm not going to read your name out. The question refers to asylum. Remember, initially we talked about asylum and refugee status. So basically, the situation is a person applies for asylum. I'm assuming that it's affirmative asylum. What happens if you enter the United States lawfully? You can apply for asylum within 1 year that you enter the United States. You can apply after 1 year, but it's even more difficult. There's certain higher standard or threshold that you have to meet. But in this case, the person entered the United States, appears to have filed asylum after that 1 year. The application was denied. And the question is, if they get married before it goes to immigration court for like a second round of asylum, will that help the case? And I'm going to just jump in. I'll try to give all the scenarios because the facts could go different ways. But yes, if you enter the United States lawfully and you apply for asylum late, let's say you're coming as a student, you apply for asylum late, after you get married, will that help you? Yes, it can. But unfortunately, it really depends on our administration, okay? It depends who the president is and what they're doing. So over the past 2 years, sometimes the government will dismiss the removal case and allow that person to marry outside of immigration court. Some administrations, they will keep that case, the immigrant petition I-130 and the 485, filed in immigration court and adjudicated before the immigration judge in immigration court. But it's like a pendulum. Every 6 months, every year, they change their policy. So, 2 years ago, it may have worked for Mr. Smith, this year for Mr. And in this case, in another case, Mr. Smith's brother, for example, it goes well because they dismiss the case and they're married to a U.S. citizen and they get their green card outside of the case. So it will depend on the administration, basically the government, and how they're adjudicating or treating people in court cases. Right now, we are seeing the courts, because there's so many people in immigration court, it's ridiculous. They are dismissing cases if people have a path to getting a legal status outside. For example, marriage to a U.S. citizen, or they have a child who will eventually turn 21, a U.S. citizen child who will eventually turn 21. So in this case scenario, there are potentially opportunities if you do get married to a U.S. citizen. Obviously, everyone knows that. Make sure you get married in good faith. They are going to grill you, check you, maybe even come to your house to see if the marriage is legitimate. And also, just a note here, whether it's asylum or family-based case, don't just assume just because you're married to the U.S. citizen, everything is going to go well. Everyone has a different relationship. Some people are very intimate, they do everything together, some don't. But the government treats immigration like the 1950s. If you ever saw Leave It to Beaver or any of those old shows, that's what they expect. And if you're not living that lifestyle, you could get questioned. Why is your husband working in California and you're still in Michigan? Okay, or whatever it may be. How often do they come back? He only comes back once a year, and they're okay with that in many cultures. In the U.S., those are red flags and could be problematic in the case. So I think, hold on. So also if the question is, okay, let's say you don't marriage is not an option. Once your affirmative asylum case is denied, it then goes to the immigration court, and you have a second bite at the apple, so to speak, okay? You have to win. Asylum cases are very difficult. It's fact-based. The emotion, the experience, or whatever the person has experienced is very important. And you really have to fight. You have to have an attorney that's going to present all the evidence and spend time with you preparing. If your attorney doesn't spend time with you preparing for the asylum interview, whether it's affirmative or not, and I'm talking like an hour or 2 hours, you're not going to be ready. It's like trial. You know, if any trial you're going to go to, the attorney's going to prep you. And if you have no preparation, you don't know what to expect, and you're sort of victim to the situation. I think I covered most of it. If not, grab another sheet and send it back up to me.
You made mention of 5 categories of work visa, and you actually mentioned 2. So what? 3. So what are the rest 2 work? You mentioned H-1B, H-2B, green card. So what are the rest 2?
Under the employment-based non-immigrant work permits, there's a lot. If you take the alphabet, A all the way through T or U, there's a visa category for each letter in the U.S. and the American alphabet. So the R visa for religious visas, there's a work visa for R visas for religious workers. Second, there's for certain categories, there's if you're a model, for example, there's H-1 for models. There's special H-1 visas for people in the government. Positions, whether you're with your home country government or working for the U.S. government, there's visa categories. There's O visas for people who are outstanding in their field, whether that's business, science, or in the sports. There's P visas. We do P visas for our athletes and other performers, whether it's musical or cultural. There's Q visas for people if you're bringing something from your home country and you want to share that culture with someone. There's a Q visa. There's numerous others, H-2As for agriculture, H-2Bs for non-agricultural positions. The H-2B sort of covers everything else. The problem is that there's only 66,000 issued each year, and every employer in the U.S. is, scrambling for workers. Does that help for the non-immigrant?
Could you please throw more light on the outstanding visa?
I can talk a little bit more about the green card areas for employment base or family base. Which would you like?
Well, I think you can touch both.
Okay. So one of the types of cases that also is very common is fiancé visas. You guys see the TV shows and everything. One of the problems we often have with couples is they don't see the attorney before they get into the process. Just like, you may do marriage counseling before you get married. Fiancé visas, you want to make sure one of the main rules is that you must have met once within the past 2 years. If you haven't met that person, it is extremely difficult to get it approved. There's got to be a reason as to why, you can't meet each other. The key is if you haven't met, if that person cannot get a visitor's visa to the U.S., then you need to meet in a third country that they can go to, whether that's Europe, Africa, Asia, Central or South America. There's many options. All too often, the second problem with that is with the fiancé visa is money. A lot of people meet everyone online, but they don't have sufficient income. So income is very important. You need to have, if you don't have the income, you can look to your assets. And if you don't have the assets, you can also look to co-sponsors. This one's already done.
Okay, I think they said, what do you think about VAWA? I filed with my family based, got denied, and in removal proceeding. I've just filed for VAWA. What are my chances?
So when a lot of people ask, what are your chances, it's very hard without all the facts and all the information. Again, one of the nice things right now under the current administration is that they're willing to cancel the removal proceedings if you have a path to getting a green card, okay? And so if you have a VAWA case, and let's say you filed it with the Vermont Service Center and it's pending, you should be able to talk to your attorney or whoever's helping you to apply to the court to get it dismissed, okay? Typically, VAWA cases are handled outside of immigration court and with the Vermont Service Center because of the sensitive nature of what you're dealing with. So whether it's VAWA or U visas as well, those are if you're a victim of a particular crime, you can get removal cases closed and allow you to get your green card through VAWA or U visas. Obviously, I think it's a good thing to help people out, right? It's still sometimes very complicated as to procedure, especially when you're in removal proceedings and the immigration courts are not very clear on their procedures for removing cases from immigration court. To give you an idea, for us to remove certain cases from immigration court, it may take 3 to 6 months to communicate with the government attorney that our clients may have the particular relief for them to get their green card outside of immigration court. So VAWA, U visas, if you're not familiar with U visas are for foreign nationals who have been victim of serious crimes, whether that's domestic violence or some felony. We don't suggest that you go like down to Chicago or Detroit and become a victim just to take advantage of that. But if you are a victim of a serious crime, then yes, there are options for those individuals.
What are my chances for employment-based green card while in removal proceeding, that is for VAWA?
Unfortunately, employment-based is a little bit different. The reason for that is family-based. If you have a U.S. citizen child or a parent or spouse, overstay of status and certain benefits are forgiven. Even if you need a waiver, it usually depends on how that impacts your U.S. citizen child or green card holder spouse, okay? So unfortunately, the employers don't get the same benefit. So while the employer can petition for you and start the process, it's not going to be the basis for you to get the green card ultimately. So for example, let's say someone comes, they oversee their status as a student, they're not married, they don't plan to get married, they don't want to get married to a U.S. citizen, okay? But their employer really loves them as a worker, they're a great worker, and the employer says, what can I do to help you? You're now in removal proceedings, you applied for asylum, but right now, asylum cases, 70% of the cases are being denied, right? So my chances may not be as high unless I have some really horrific facts. So having that employer petition is fine. The problem is if you were removed from immigration court, there's no waiver or anything that can be done for the employer to overcome the overstay of status or the immigration violation in this case. So that can be a challenging. Having the employer help you doesn't really solve the immigration violation that may be present.
What is the possibility of someone already received a nod and has been replied but never had any response from them? If it is not granted, what next can the person do?
Just to double check to make sure I understand the question well. A nod or notice of intent to deny, NOID, is where the government has, on a pending case or even on an approved case, has decided that they're planning on denying the case unless you can provide certain information. Another form is sort of, with a pending case, is what's called a request for evidence, or RFE. So in a notice of intent to deny, and I mean, obviously, hopefully, when you respond, you have enough evidence to overcome whatever the issue is, okay? That should be successful. If it is not, it really depends on your visa category. For example, if this is based off of a green card, did you maintain your underlying status? Let's say you're an F1 status, you marry a U.S. citizen, and for whatever reason they send a notice of intent to deny regarding the marriage. Did you maintain your student status? Well, then if the green card is denied, you can still rely on that underlying pending status, okay? I'm just adding facts in here to kind of substantiate because they're not all here. If you have a child that's born that's a U.S. citizen, obviously, yes, the child can petition for you in the future, but often the children are young, which means they have to wait until they're 21 so that they can help you out. So that's a long wait. If you have a child that was born in the United States and you expect that child to help get you out. Will it get you out of removal proceedings? Absolutely. That's great. But is it going to get you a green card anytime soon? Probably not. Let's see. Okay, I got the age. 21 is when the child can petition. U.S. citizen children can petition for the parent in that case. Yeah. I think we covered most of the scenarios or options on that one. If I missed anything, feel free to write it again and let me know or ask questions.
Yeah, so talking about the F1 visas. Mm-hmm. So if somebody in the category of F1 go out of status, how possible? Or does he have a certain number of months, years before he can go back? Or if he decides to, maybe after 1 year or 2 years, he decides to go back in the status, will he be reinstated? How does that work?
So for F1 students, people who come over here to study, the goal is that you study full-time. Okay? If you don't study full-time, then the university has the obligation to tell immigration that you're out of status. Now, there are procedures to get the student back into status, meaning you would get issued another I-20 to show, and that would be your legalization. We give some grace to students, which is nice, so there is that potential. Where is that bright line that says you can no longer get reinstated? There is no bright line, per se. It really depends on the university of what they're able to do, and also the university, what they do is they have a system called SEVIS. The SEVIS system, they'll put all the students' information in and submit it. If immigration or ICE, Immigration and Customs Enforcement, approves it, then the person is back in status. My recommendation, of course, is the sooner the better. I wouldn't wait 1 or 2 years. You know, it's really ultimately up to the university whether they even want to deal with that. And then secondly, whether immigration will even permit it. So you don't want to take those chances. If you are a student and for whatever reason you can't study full-time, leave the country, apply, come back. Or try to change your status into something else in order to, you know, at least change to a visitor's visa to buy you time, okay? But do something. Do not do nothing and expect the government to get you out of it. So that's for F1 students. Study, get your degree, get your H-1B, get your green card. That's the best way to do it.
Mm-hmm. The online question is it possible for someone to get an employment sponsorship while the person is already here?
The simple answer is, of course, yes, it is. You do have to maintain your status here in the United States. If you don't, then it will be next to impossible. So if you come to the United States on a visitor's visa and you overstay your status, and let's say you're an engineer, doctor, doesn't matter, lawyer, and you then get a job offer, no, it will not help you. They can even sponsor your green card. When I say it cannot help you, let's say they cannot help you get a visa to legalize your stay here. They can even still apply for your green card. The problem is that you have an immigration violation again. You would have to leave. If you're here and in violation of immigration laws, you could be barred from coming back in. So we don't want that to happen. So if you're here lawfully, absolutely. If you're here in F, TN visas, H-1Bs, whatever it is, there's a numerous visa categories. Yes, you can have an employer sponsor you, and you can change status and start working.
Another one, what is the possibility for a U.S. citizen to invite a niece who is a minor to visit the U.S.? The minor is about 15 years old. Is it possible?
Well, in immigration, all things are possible. It's not scripture. But in reality, unfortunately, our government discriminates against a lot of people out there, certain countries. And it's kind of hypocritical. Here in the U.S., we talk about not discrimination. We do our best. We're fighting this, lawsuits and everything. However, on the immigration scene, the government does it all the time. So typically, there's two things you have to show for a visitor's visa. One, that you're coming for the proper purpose, okay? The second is that you're going to go back, okay? You have to have ties to your home countries. The problem is you really only have one shot at it, and depending on your background, they're going to prejudge you, okay? So unless the person has traveled to multiple countries but many times and returned to their home country, or they're coming on business, it's going to be, for many countries, not all, for many countries, it's very challenging to get that B1, B2 visa approved. It just is. You can be a single mother, you can be a young niece, 15, but the problem is they have family. You may have all the best intentions, but it's just, they're just going to say, nope, we don't believe you, and they'll just deny it. Now, the other sad part of it is the consulates don't have to give you a real reason. They give you a verbal reason, but that's it. There's no written reason for you to fight. There's no appeals court. There's nothing you can do. So all too often when people tell me the scenarios of the fact situation, I ask, have you traveled multiple times to other countries in and out recently in the past 5 years? Are you employed? Okay. Are you married? Do you have obligations in your home country to bring you back? Okay? So we would be asking all those questions. And I often tell people in many situations, just don't waste your time or money. As you guys probably already know, because of the pandemic, there's a huge backlog of cases. So even to get a visa appointment on a visitor's visa can take months. In some countries, it's almost a year just to get a visa appointment. And then to get denied after waiting a year. This often comes when we have fiancés who's like, oh, I just want them to come over and then we'll figure out whether we're going to get married. But the problem is that person just can't get the visa. And they wait a year. They don't believe us. They go ahead, they wait 6 months, they apply, they then get denied. Now, again, as in the sample, there's stress on the relationship. They already waited 6 months. They don't trust our government. They don't like our government. And now they got to wait even longer to go through the fiancé visa, or if they're married, the immigrant visa option. So 15-year-old, probably not, but it will depend on how often they've traveled and strong ties to show that they're going back. Kids who are 15, they don't have a job. They have really no responsibility to bring them back, so it could be very difficult.
Okay. This question is that can an asylum status be denied upon submitting online? What could be the reason why feedback is delayed to be given after turning and notice that your application was received?
Not quite clear the question, but let me try to answer. If not, let me just repeat it, okay?
Let me say maybe in my own...
yeah, go ahead.
Yeah. Is that submitting an application for asylum online, can that be denied? And say, what could be the reason why they would deny the application that was submitted online? And why is the feedback delaying to be given after you've seen the notice that the application has been received online?
Okay, so if no one's really noticed, last administration, they essentially gutted our immigration system out. And at the consulates, everyone quit. It was just an ugly, toxic work environment. So a huge amount of wealth, knowledge, experience just left immigration, both in the U.S. and abroad. Because of that, they've got to rehire people, they've got to train people, and they've got to be competent. And we aren't there yet. We had hoped with the new administration that that would be quick, but as I just talked about earlier, U.S. employers can't find enough people to work. The government can't, no matter how much you pay them, people don't want to work. We don't have enough people. So getting new people in, training them so they're competent and can move these cases quickly is huge. Another problem, asylum cases. Up to this year, there's about 800,000. By the end of 2024, there will be over 1 million affirmative asylum cases. Even if they wanted to get through cases quickly, they don't have the manpower to do it. I always encourage people, if you want a job, USCIS Asylum Office is looking for people. I mean, you can get a job, okay? They're looking for people, but they don't have enough. So are online cases denied? Yes. Why are they denied? It could be many reasons. Maybe the forms are not, before, maybe the forms were not completed properly. Maybe maybe you haven't articulated what your fear is, okay? Typically they're not going to be denied until you have an interview with the officer. And if it's getting denied before then, maybe the filing process or something, it seems very strange. You just fill out everything, complete everything and file it, and you shouldn't have a problem to get it filed. And also after 150 days, you can file for your work permit. Did we cover everything in that one question, or was there other things that I missed?
Yeah, I think that's it.
Okay.
Yeah. Is it why in asylum, I believe, it says status, can you change to either marriage or employment-based status?
So whether you're in asylum status, it really depends on how you enter the United States. If you enter so either way, yes, to answer that question. If you marry a U.S. citizen, if you marry someone who else is illegal, which a lot of people do, or if you marry someone who's a green card holder, that doesn't help, okay? But if you marry a U.S. citizen, yes, even during asylum, that can get you on the path to a green card. Is it a short path? No. Is it quick and easy like Amazon? No, it's going to take time. Well, I mean, that's what we get. People who do not understand how bad things are, or maybe they read something that was from 5 years ago, they think that's how quickly their case should go. They don't understand that for certain waivers, it's taking 4 years for the government to get through them. 4 years. It's ridiculous. There's lawsuits out there. The problem is even with lawsuits, you got to have people to process. AI has not solved this problem, and I don't know if we really want AI to solve this problem either. It may be good, but it may not be good.
Yep.
So.
Yeah, and is one allowed to travel out of the U.S. while waiting for their asylum status to be approved? Maybe they have work authorization.
When you're in asylum or even in immigration court, you need permission to leave. So do not leave the U.S. unless you have permission. The application you apply for is advanced parole. That's on Form I-131. There are many reasons. Now, the question is, do you go back to your home country on that advanced parole? Probably not, if you're saying you fear going back to that home country, especially when you haven't even done your interview, because the officers will use that against you, and it's going to be hard for you to prove that, I was unable to go back to my home country, and I did. So can you get work travel document? Yes. Sometimes it is limited, and it will take time, but yeah, you can do that. Some attorneys probably don't recommend their clients to do it because the problem with us is we can't control you and what you do, okay? And you tell us one thing, and then you get on the plane to go see your aunt, your cousin, whatever, your mom, because they're ill. It's always something. My mother has cancer. She's on her deathbed. I had to go. And that's reality. Life happens. And so that's why a lot of attorneys, because we can't control that, we're here to try to represent you, get the best case for you. We're going to, often say, don't do it, even though it is possible.
Okay. What are your thoughts on NIW application? What is that?
Remember, I've been practicing immigration law practicing law for 23 years. So for the most part, I'm a little cynical on the government improving things because nothing really has changed. On options, if you qualify for NIW, which is what is called the National Interest Waiver, it's under the second employment-based preference category. Yes, if you qualify it, yes, that's good. You should apply for it. We've done it for executives. We've done it for researchers. Medical field is excellent for NIWs. Anybody in those fields. Recently we got one done for a lady in the medical field here in Chicago. I mean, people do it all the time. Are they challenging and difficult? Yes. Do you have to do something a little extraordinary or different? Absolutely. If you just went to college, graduated, and you're working at an accounting firm and you're an accountant, probably not going to get approved. But there's many ways for the attorney to use the information to win NIW cases. Are they expensive? Yes. Do they take a lot of work? Absolutely. But you can file the I-140 National Interest Waiver without exposing yourself to anything else for the most part. Sometimes if you're a student, F1, you may be a little cautious, or a TN visa, but for the most part, you're not losing anything other than time or money.
I believe. So what scenario can play out at the point of entry that can lead to refusal of entry for a family on a holiday trip after visa has already been granted?
If we're talking about a family coming to visit that's on a B1, B2 visa, visitors, many factors can play into that. Kind of what we talked about before is, are you coming for the proper purpose, and are you really going to return? Okay? And the CBP officer at the port of entry is going to make that call. You have one shot, you got to convince them. Again, multiple travels to other countries and returning to your home country is perfect. If you have that evidence in your passport, it's going to show up in your passport. If you have employment or business or obligations to bring you back home, that's good. Try to bring evidence of that, but at least verbally say that. And if they want to see evidence, then they'll, take a look at that. But it really is just what you tell them at the port of entry and how you're coming in to show that you're going to go back. And no matter how much you say or, documents you have in your backpack, they're just going to go off of what they see initially when they see the person.
I believe our time is up. After this one, whatever we have, we can leave. We can just send them, and I believe Ray will get back to us on that. So I just have two questions quickly.
As I say in immigration, there's never a quick question, even though someone says it. But go ahead.
Okay. If one F1 visa expires before the duration of studies end, does one have to travel back home to country of origin to renew, or can one renew in here without going back home?
So for F1 students who are here, let's say you enter the United States in B1 or B2 visa status, lawfully you do not need to go back. However, it depends on when your I-20 is issued and when you can start that process. So there's a timing issue. So if your I-20 is valid and you try to change your status from visitor to green card, to F1 status, the processing time right now can take almost a year. So that I-20 is going to be invalid. You're going to have to get another I-20. So can it be done? Yes. But will it interrupt your start date depending on when you want to start? Absolutely. Now, even more importantly is the university. During COVID, a lot of universities were telling, or prior administration, the universities were telling the students to go back to their home countries, even if they're already in the United States, to get a visa stamp, which is not always feasible, and it's very expensive. It's not required by law. However, the university is going to control how that student acts. So ultimately, it's up to the university, and you have to follow what they require, even though legally it may not be required from the attorney standpoint. We cannot force your university to do things differently. They're in control of everything. So do you need to? Absolutely not. It depends on the facts and situations. You have to get more details and facts of what their category in. Now, if they're out of status or they overstay their status, then you cannot change your status, okay?
Even with F1?
The general rule is no, you cannot. There's a rule that's called for discretion. There's a rule that's called for discretion. The USCIS may, in its own discretion, forgive that overstay status and allow it, but it's not a given. It's not something you should base your future on. Unless, I mean, it's a lot quicker also to, well, generally it's a lot quicker to get an F1 visa stamp in your home country and come back in. It depends on the country you're applying for and how backed up they are.
Okay, thank you. Yeah, this last one, I believe, after
Okay,
marriage based has been denied, can the person file for asylum based or any other way? Or what can the person do in a situation when the case has been denied and asked to leave the United States?
Well, depending on the facts, refile. That's one option. And make sure you resolve any issue that there was before. The second thing would be, typically you're in removal proceedings, and you can argue your case and show that you got married in good faith in immigration court. The other, can you file asylum? You can, but it's most likely from the discussion going to be late, and you're going to have to show a reason why you didn't file initially, or if there are changed circumstances within the past 6 months. You can't go into other visa categories unless you have maintained your status. So there's two things. You have your green card and then maintaining your status underneath. If the person is maintaining their status underneath and they get their green card denied, you're okay. But if you haven't maintained your status underneath, you know, that non-immigrant status, it's going to be problematic, okay? So it really depends on the reasons for denial. You know, if it's marriage fraud, then yeah, you might want to get on the plane and go back. So.
I guess we'll have one grace period, right? Grace. I'll just ask the two questions, then we are done.
Sure.
Yeah. Can someone travel in and out of America with F1 student visa? Then the second question is, what is the chance of a child with a B1, B2 tourist visa to enter while the parents are currently in U.S. without resident permit yet?
Okay, so the first one, F1 status, can they travel in and out of the U.S.? Yes, they can. Of course, when they leave the United States, they need a visa stamp to come back in. Before they leave, they have to have a valid visa stamp. If they already have one, great, go in and out as much as you like. If your visa stamp has expired or you don't have a F1 visa stamp, then you're going to have to obtain one traditionally in your home country before coming back in. Okay? The second one, where the parents are here illegally and their child is trying to apply for a visa,
I
B1,
believe
B2.
they say already have the visa, but I think he's just trying to come in. I believe so. What are the chances of a child with a B1, B2?
It depends. If the parents are here lawfully,
That's a without permit, which means
illegally.
illegally.
Yeah, or overstayed their status or
Yes,
entered
overstay,
illegally.
yeah.
Either way. If the parents are here without status, we'll say that,
Yes.
then it's going to be very difficult for that child to come into the United States. Okay? However, not impossible, it's going to be very difficult. It depends on the reasons why. Okay? on their application, they have to say, do you have any family or relatives in the United States? Yes, I do. They're going to have to disclose that. If they don't, they're going to put a false application to get a benefit. They'll be denied forever. So when they disclose their parents' information, that will be problematic. The government will look into that and most likely say no. I mean, what's the reason? There's just going to be no reason for the child to come. And the government is not going to help. One of the things, unfortunately, I try to tell people is U.S. immigration is not empathetic and they just don't care. And that's so hard for people to hear or understand. Even if you're a U.S. citizen, doesn't matter if you're a U.S. citizen, you can't, and when it comes to immigration, they have no empathy, they really don't care. It's a really sort of red line approach to the way that we administer. Other areas of law, there's discretion. Is this your first crime? We'll give you a break. There's things that are built in other areas of law that we just don't see in immigration, unfortunately. So you have to get it right the first time. You have to follow the rules. I want to thank everyone for a lot of great questions. Appreciate it. Again, if there's any other questions, go through the pastor, let him know. He'll get them over to us, okay?